The main topic today is the CFMEU case, which went before the High Court as an original jurisdiction because there was an argument by 4 members of the CFMEU saying that the appointment of an administrator would prevent them from being able to use the resources of the Construction and General Division of the CFMEU to prosecute their implied rights of political speech.
Right.
Tell us what happened.
So, the new laws that have come were introduced in 2024 establishes a scheme for the administration of the Construction and General Division of the CMFEU.
Yeah.
And the administrator, Mark Irving, I believe.
Yeah, has a silk. Yeah, who was appointed.
So he has taken control and put them into administration.
Yeah, he will. He, as part of being an administrator, will take control of the resources.
Right.
And so these four people representing the Construction and General Division said, well, look, when he takes control of those resources, I can't use them to prosecute this implied right that I have under the Constitution to say what my political views are and to challenge other people's political views. And what this put, and it's not been decided by this case, in fact it's been put off in some ways, is, well, what is this implied right of political speech that you have?
Yeah.
And what the High Court found is, well, this legislation was created to deal with dishonesty, criminality and things within the CFMEU in a dysfunctional organisation. And there has to be a method of controlling the potential misuse of monies by appointing an administrator. And if that has the effect of reducing your capacity to actually fund political speech, it's not a breach of any implied right. But what the unanimous decision also said is, this is not an issue we need to determine in full today. It's something that deserves a proper discussion in itself. But in the circumstance of this case, where you have an organisation where it is argued that there has been dysfunctionality around the use of money, that there must be a method of remedying that, and the appropriate method is to appoint an administrator, and therefore it will prevent some of the things that you may want to do by spending resources, but it will not infringe your implied rights under the Constitution.
So just to be clear, are they saying that it's not a breach of their implied right, or it is, but there is a good reason for it?
No, it's not. What they haven't been able to define, Tom, is what does that implied right actually look like?
Yeah, what it's not an absolute right like in other countries.
It's not an absolute right. So it is a right that exists there, but clearly where there is dysfunctionality within an organisation, particularly around the use of monies, the appointment of the administrator is an appropriate step to take. And if that prevents you allocating resources
towards political things,
then so be it.
Yeah.
Doesn't stop you talking, doesn't stop you going out and arguing, doesn't stop you doing any of those things. It just prevents you from using the resource. And the argument was all around the use of resources.
Yep.
Well, I reckon it's probably time now for us to go on and have a look at our case study.
Case study?
Which should be pretty novel for you because I suspect you haven't read it, Tom. So here we go.
Let's see how we go. Okay, so Nancy did not get along with Millie. They both worked for Cedric, an older man who, even at his loudest, was circumspect. Nancy and Millie were payroll and debtor clerks respectively, working under Cedric, the company accountant. They both complained to Cedric about each other, found fault with each other's work, and drove Cedric spare. Cedric raised the issue with Naomi, head of people and culture. She expressed her dissatisfaction with young kids at work and told Cedric to keep them on a tighter leash. Cedric called them into a meeting room. He explained that they were always unhappy with each other, never supportive, and that both of their work was suffering. He asked them to stop it, to be respectful, and warned that if the behaviour continued, he would have to begin a formal performance management process. Millie left the room first. She was sad and dejected. Nancy stayed behind. She glared at Cedric and said, "You're just going to let her get away with everything, aren't you?" Cedric replied that he didn't share Nancy's view of Millie. Nancy stood up and stormed out. Seconds later, Cedric heard a terrible smashing sound. He ran to the end of the corridor. There was Nancy, blood dripping from her arm. She had punched a hole in a glass window. Cedric took out his clean handkerchief, pressed it on the wound, and asked her why she had done it. Nancy wasn't hysterical. In fact, she was quite subdued. She looked at Cedric in a menacing way and said, "Because you're a do-nothing, you're a do-nothing fucking idiot." It makes me mad.
Effing idiot.
And it makes me mad. Cedric was angry now. What a foolish and rude woman. In a calm voice, he said, "That's it, Nancy, you're fired. You're rude, destructive, and aggressive." Okay.
All right, so there's the facts, mate. So
Yep.
let's see what the first questions are. I tell you what, our teleprompter's running a bit slow today. It's not built with good gas, has it? Okay, so the first question is, Millie made a worker's compensation claim alleging her workplace was not safe and that it had caused her to suffer anxiety and depression. Her doctor agreed. Will her claim succeed in Victoria or elsewhere? So, Tom, in Victoria, it's not going to succeed. And the reason it's not going to succeed is since the new amendments have come through, that type of dispute that arises between two people is a defence for rejecting a claim. Okay, so she wasn't present during windows being smashing, but between the two of them over a period of time, there'd been a level of frustration and difficulty, but there was no proper basis under current Victorian law. In every other jurisdiction, probably not New South Wales after they amend, but in every other jurisdiction, it would be compensable. Okay.
Okay.
The next one is, if Nancy commenced a general protections claim alleging her sacking was due to her raising a complaint about Millie, would she succeed? What do you reckon, Tom?
I'm not sure because I read the facts and they didn't really register.
Okay, no, well that's not great, really, is it? So the answer is, Nancy's allegation is that there was this disagreement that existed between her and Millie, and she says on that basis that she's raised a complaint. Yep. She's complained about this behaviour. Nothing was done about it. Therefore, you sacked me because I raised the complaint. Mm. And Cedric says what actuated him sacking you is you punched a hole in the window and you're disruptive, rude and aggressive and I won't tolerate it. And there was two examples of that. So she would fail without a doubt on a general protections claim. The next question is Nancy, this is the window puncher, makes a workers' compens claim for serious, full-thickness, deep lesion on her arm caused by smashing the window. Is that compensable? What do you reckon?
Well, I feel like this reminds me of the case we just talked about.
The donuts case,
yeah, like that's so far outside of her, what she's meant to be doing.
No, I totally agree with you. I might say in New South Wales 2 or 3 years ago, it probably would have been accepted, but the answer is it should never, ever, ever be accepted.
Okay.
Is Nancy's injury a notifiable incident under the safety law? I'm going to deal with this one, Tom.
Okay.
Okay, so the answer for this is not as easy as it seems. So it is prima facie notifiable because it occurred in a workplace and related to an injury that suffered from a workplace structure.
Yep.
So unquestionably, it probably should be notified. The issue is there are variations from the Victorian theme in other states and territories which would say that there must be some greater connection to that for notification. And my view is that the intention of the Victorian legislation is also there must be some attributable part of work. But I think for the purpose of the attribution as that is the level of stress and anguish that occurred in the circumstance leading to it. So this is definitely a notifiable incident.
Yep.
If Nancy made an unfair dismissal claim, was Cedric's process so flawed that a claim would succeed? If so, what would be the remedy?
Well, he has sort of fired her on the spot after she's lashed out at him.
Yeah, I put this one because I think at this stage his response to exactly what she just did is so self-evident that I'm not sure that the lack of procedural fairness would be fatal, but the case law would suggest there's a high likelihood it would be fatal, okay? So it may be that it wouldn't succeed, but her remedy would be very small. It would be just her normal notice period and there'd be a significant discount for misconduct.
Yep.
Okay? Were there other safety breaches by Naomi, Cedric or the company, and if so, what would be the charges, why and the likely penalty? Now, the reason I've said this is, although this may not be compensable in Victoria, clearly their failure to deal with psychological hazards is a breach of safety legislation primary duties. When two people are arguing and it's causing them stress and harm, that's a psychological hazard. Their failure to intervene is a breach. I don't think they'd ever be prosecuted, I might add, but unquestionably there is a breach. So I don't think charges would be laid. I don't think there'd be a penalty. But I'm not saying in 5 years' time whether that would be the case, because we'll see regulators increasingly stepping up, but this is at the very low end of where they would step up and they wouldn't get authority to issue proceedings on this one.
Okay.
So there you go, guys. That's the end of it. It's a bit of a wild old day today. We're running against time. We're a bit tired, a bit weary, and we've all been sick. So you're lucky to have any of us, really. That's the short answer. Thanks for stepping up, Tom. Thanks, Toy, for putting up with us. And we'll see you next week. Cheers.